Thank you very much. Welcome to the appellate court. Our first hearing is virtual. It is AC 42742, Randolph v. Mambrino. And we do have Mr. Randolph on video, and his audio also works. We check that. So just to let everybody know, both sides have 20 minutes for their argument. Mr. Randolph has been told that he can reserve a portion of that 20 minutes for rebuttal to use after the state speaks. He'll let us know what amount he's reserving when he introduces himself. Please try and remember to turn off your audio when you're not speaking. We'll try and remember to do that also so that this can be recorded, and the recording will be posted up on the website later today. If by chance you get knocked off the video, no worries. We won't be doing anything in anyone's absence. Just try to log back in. And we also have the assistance of our judicial IT to help with that. Okay. And finally, I will be, as best I can, keeping track of the time on my iPhone stopwatch. And I will hold up this 2-minute sign when you have 2 minutes left, both for Attorney Chupak and for Mr. Randolph. Okay, so I think we're ready to go. Good morning, Mr. Randolph.
Good morning.
And you wanted to reserve some rebuttal time?
Yes, I wanted to reserve 5 minutes.
Okay, 5 minutes. Yep, we'll do that. Okay, so you're ready to go.
Yes.
You can start with your argument.
All right, so my appeal is we was first arguing fraudulent concealment because the prosecutor, Donna Mambrino, this case happened August 24th, 2012. All right, so around January 15th, somewhere around there, Donna Mambrino received evidence that I was innocent. She was in touch with somebody that picked up one of the guys that had did the robbery. All right, so now we arguing that. So the evidence was the letters that was received in the mail to Attorney Bruce Lorenzen, Donna Mambrino, the judge, I forgot the judge's name, and I was sent one. All right, so Donna Mambrino was in possession of this information in January. After that, she was forcing the issue for a plea deal. I had asked Bruce, why is she so in a rush? What's going on? All along, she had this information and was not turned over to me. So I asked Bruce, what's going on? And Bruce said, she blamed me for a colleague losing her job. Her colleague, she had a case with me, a murder case. She had people lying on me. I have that paperwork too, but what she said was that she don't care if I'm innocent or not. She's getting a conviction. So fast forward, I plead guilty. Bruce said, just plead guilty and then we take your plea back. I do that. Bruce can't take my plea back. All right, so now,
Mr. Randolph,
I filed for, yes.
may I interrupt for just I have a quick question.
Yeah, sure.
Did your lawyer have the same letters that uh, Ms. Mambrino had?
Yes. He got
So
them
how,
after.
if you had those letters and he had those letters, how were you prejudiced in any way? If you had that information,
Oh, no, we got the information after I pled guilty. We got the
oh,
information
okay, okay,
prior.
that's what I thought. That's what I thought. I'm
Yeah.
sorry, I just was confused about that. You did not
Yes.
get that, you did not get that information. You didn't get the letters until after you pled guilty, is that right?
Into after, yes. Like
Okay.
a
All right.
year or something after.
Okay, that's, okay, I, thank you.
All right. So now I do the subpoenas. So everything is in order. File the subpoenas. I get notarized 8/2/2016. They get sent back saying lack of nature, meaning that they said that I sent them out late. Now, this is what I don't understand. If I have paperwork, very important paperwork, notarized 8/2, why would I wait more than 30 days to send it out? It doesn't make any sense. So they send it out, they send it back, I resubmit it. It's good. The dates and everything is good. Then it go from it being good to statute of limitations. Now, this is where it gets funny at. Statute of limitations, right? Even the prosecutor agreed the paperwork was filed on time. Even she agreed with it in court. While we arguing, turn around, now I'm 4 days or 5 days late. Statute of limitations done ran out. But when she's arguing that about the statute of limitations, all right, so we still arguing the prosecutor withheld evidence, fraudulent concealment. Now, I even use the judge as an example. If I have evidence that you are innocent, I don't turn it over to you. You get the evidence from somebody else after you plead guilty to these charges. What did I do? The judge said it. I fraudulent, like I concealed the evidence. All right, that's what we've been arguing. The prosecutor had a duty to turn over this evidence. The letters, she had these letters for more than 8 months, more than 6 months before I was forced to plead guilty to a crime I know I didn't commit. Excuse me. Sorry about that. She had these letters for like 8 months or 9 months. Like 9 months before I pled guilty. If she would have turned the letters over, I wouldn't have never pled guilty. Just like when judge said accept or reject, I rejected. We was going to trial. Me and Bruce, we got into I wouldn't say an argument, but I kept telling him in the courtroom, I'm not pleading guilty to something I didn't do. The judge asked us going back and talk. We got loud back there because he kept saying, just plead guilty and you could take your plea back later. No, I'm not doing it. All right, so what would convince me to plead guilty to a crime I know I didn't commit unless Bruce said he could take my plea back. I did it. Right after that, I got a legal visit, so I asked him about that. I said, Bruce, did you find out anything? He said no. I said, so what about my plea? He said, that's water under the bus now. No, it's not. So as time went on, I'm convicted. He sent the investigator up to see me. He asked me if I received an email. I said, no, why? He said, no. He said, if you receive mail, don't say nothing to nobody. I said, what kind of mail? He said, I can't tell you now. I said, but if it's coming to me, I want to know. A week later, that's when I received these letters from a girl named Iris. All right, now, it's all good. So we arguing. I'm representing
Mr.
myself.
Randolph, those letters
Yes.
that you held up, are they signed?
They just got her, they just got Iris S. The prosecutor Mambrino.
Now, are the letters signed by Iris S?
No, I don't see no.
None of them are
signature.
signed.
No.
Okay, so you don't actually know who they're from.
No, I don't know who they're from, but.
And then I had another question. The letters you're holding up, are those letters dated?
Yeah,
Everyone has a date on them?
Yeah, 1/18/13.
What about the other? Does every letter have a date on it?
Yeah.
Well, that's interesting because the judge said in his opinion that 4 of them are not dated.
Just the first one. Just the first one is dated.
Okay.
6:30 p.m. 1/18/13.
And the others are not dated.
Nope. It's just the first one. The first one was to Donna Mambrino.
So they're unsigned and 4 of them are also not dated.
Yes. Yep.
Thank you.
All right, so now, as we arguing, the judge, he had told me to get some subpoenas together and questions. All right, so I get the subpoenas and questions together. I give him the subpoenas in court. Is a continuance. He go on vacation or whatever, but when he came back, the subpoenas was not signed. So what he did after he said I was gonna be able to question everyone involved in it. Eric Gamble was incarcerated. Bruce and Donna worked at the courthouse. Iris, I don't know her. So what he did, he signed a subpoena for Iris with no last name, no address, nothing. Just that was the only subpoena that he granted. Now, the prosecutor said this is not a fishing expedition. No, I said it wasn't a fishing expedition. It was something to get into the truth. I want to ask them simple questions. Why didn't she turn over the letters? And why didn't Bruce have knowledge of these letters? Like I said, she received them first. That's what the letter said. She was in contact with that young lady. That's what the letter said. Now, during these procedures, he kept giving me time to find her. How can I find her if I have no address? The prosecution had the address and everything. I had no address or nothing. Now,
You see you have 2 minutes, right?
yes. All
Okay.
right, so when she called in the guy that delivers the paperwork, the subpoenas and stuff, he couldn't even get his story straight on the stand. So that was a waste of time of me even questioning him, because she kept correcting him and telling him what to say. So that was there. But the bottom line, my subpoena was sent out on time. When the judge found out who the clerk was, it was his clerk. He said, oh boy. It was his clerk that signed and sent it back. I don't understand, why would I get something notarized and hold on to it for more than 30 days when I know I'm innocent? And for the prosecutor to withhold this evidence that was fraudulently concealed, actually, is exculpatory evidence. No way would I have pled guilty to something I didn't do, one, and then Bruce asking me to plead guilty, and he would take my plea back. Two, it doesn't make any sense of me pleading guilty to something that I didn't do. I'm trying to remember.
This would probably be a good place to stop, and you have your 5 minutes all saved up. Okay.
All right.
Okay.
Thank you. How do I mute this?
Okay, we're going to hear from Attorney Chupak now.
Thank you, Your Honor. May it please the court, my name is Nancy Chupak. I'm a senior assistant state's attorney with the Office of the Chief State's Attorney Appellate Bureau. I represent the respondents in this matter. Just a few points on the first issue. The trial court properly granted summary judgment because the petitioner's petition for a new trial was time barred. Despite the convoluted procedural history at play in this case, the trial court was correct that this case comes down to the Turner and Fischera decisions. In Turner, this court determined that the statute of limitations in 52-582, which pertain to petitions for a new trial, was jurisdictional. And it did so based on what it found to be clear indicators of legislative intent to make the statute of limitations jurisdictional, including the specific language and what was included in that language and not included. And as a result, the court ruled that common law equitable tolling doctrines did not apply to 52-582. In Fischera, our Supreme Court determined that 52-595, which codified the common law equitable tolling doctrine of fraudulent concealment, did not apply to the jurisdictional statute of limitation in CUPTA because there were clear indicators that the legislature did not intend for it to apply. And these indicators included, again, the language used by the statute, the mandatory language, and also the fact that there was the statute of limitations did not refer to 52-595 or even equitable tolling or good cause generally. And the fact that the violations were defined within CUPTA to include deceptive practices. The Fischera court's focus on legislative intent was particularly appropriate with regard to whether there were exceptions to the statute of limitations, because when a statute of limitations is deemed to be jurisdictional, the remedy created by the cause of action is said to exist only during the prescribed period. And as a result, the remedy cannot be extended unless there is a clear indication that the legislature intended it to be extended. Just as in Fischera, there exist here clear indicators that the legislature did not intend 5295 to apply to the statute of limitations pertaining to petitions for a new trial. They include not only some of the same ones that were in Turner and Fischera. The legislature used mandatory language here: no petition for a new trial in any civil or criminal proceeding shall be brought but within 3 years. The fact that the legislature included in 52-582 specific exceptions to the 3-year limitation, and none of them referred to 595, either specifically or equitable tolling and good cause exceptions generally. And as our Supreme Court noted in Ramos, the legislature amply knows how to provide good cause exceptions to time limitations if it intends. The fact that the legislature amended 52-582 after Turner had determined that the statute of limitations was jurisdictional and limited a trial court's authority to apply equitable exceptions, and yet the legislature didn't include any amendment for equitable tolling exceptions. And significantly, the fact that the legislature amended 52-582 after Turner expressly questioned the applicability of 52-595.
Ms. Chupak, does it, Fischera involved CUTPA, as you've discussed. It seems a bit odd to me that we would, and I understand, the points you're making are good points, but it seems a little odd to me that if a defendant, a petitioner, can establish the 4 requirements, under Asherman to obtain a new trial, in connection with a petition for a new trial, and can establish that the state fraudulently concealed the evidence, that the state's interest and the public's interest in finality nevertheless trumps and the individual's interest, liberty interest, in rectifying what is apparently, an injustice of some kind. Again, assuming the facts as I'm not suggesting that's the case here, but we're talking about this more broadly, more generally. As a policy matter, why would the legislature decide that in a circumstances where the state has fraudulently concealed evidence in an effort to deprive an individual of the opportunity to file a timely petition for new trial, why would we conclude that the legislature would determine in that circumstance that the finality of the criminal conviction is the overriding consideration?
Your Honor, I don't think it's finality is an overriding consideration, but 2 points. One, it's the vehicle that the petitioner is using. With regard to petitions for a new trial, and with regard specifically to the 3-year statute of limitation therein, that was a balancing. It was a balancing of the petitioner's need to the petitioner's, or I should say plaintiff or criminal defendant's ability to have a way to redress an injustice, not only with upholding finality of judgment, but also the state's ability to retry without losing evidence. That's part of it. And also because petitions for new trial are only one of very few statutory exceptions to the common law rule that a court's jurisdiction terminates at the rendition of judgment. It's a derogation of the common law and is supposed to be construed narrowly. That all said, so there was a balancing there with regard to the vehicle of a petition for a new trial. That being said, a petitioner who has suffered an injustice, a Brady violation or fraudulent concealment, has a means to another vehicle, and that is habeas. And that could be either via a claim of actual innocence or via a claim of due process. So it's the vehicle used. And
so this would, let's assume for the moment that the allegations have been properly pled, or that let's assume the allegations are provable in this case. Because I know that there's another, you know, the trial court, in essence, well, in any event, is it the state's position that Mr. Randolph could, if he doesn't prevail here, he can turn around and seek relief via habeas, you know, raising a Brady claim?
Yes, it is. And he actually had done that and then withdrew it.
It wasn't opposed because that was not the proper avenue. It's, in your view, it is the proper avenue.
Yes, it's the proper avenue, not a petition for a new trial. That's the state's position. Because 52-595 does not apply to toll the running of the statute of limitation, and petitioner conceded below that the statute of limitations had run before he brought his cause of action, there was no issue of material fact, and the trial court properly granted summary judgment. With regard to the respondent's alternative argument, the respondents rely on their brief unless there are questions.
So you answered Judge Palmer's question in footnote 15 of your brief, right, with respect to the habeas?
Yes.
Got it. Thank you.
Thank you. The respondent requests this court affirm the trial court's granting of the summary judgment and dismissal of the petition for a new trial.
Thank you, Attorney Chupak. Okay, Mr. Randolph, you do have your 5 minutes to respond to the state's arguments. Okay.
All right, yes.
Could I ask you a question, Mr. Randolph? You appear to
Yes.
have filed a habeas action, correct?
Yes,
And then you withdrew it?
yes. Yes, I withdrew it because I was in court doing a petition for new trial for newly discovered evidence, and the prosecutor kept trying to get me to put them together and do the habeas. No, it's totally different. Newly discovered evidence, and what I don't even know what the habeas was for. I don't even know what the habeas was for.
Mr. Randolph, is it your position that these letters that start out with "This is Iris," although they put you near the scene of the crime, they exonerate you and make somebody else the perpetrator of the crime?
Yes, they clearly exonerates me. I wasn't involved in a crime. I had gotten to the vehicle after someone else had gotten out. I had just gotten off work. And then as I read these letters, I realized if I wouldn't have gotten into the vehicle, the guy, Eric, they would have killed him. And what she said about 52-595 limitations, petitions, new trial. This is what I don't understand. Like everything is put against us when we meet the 4 prongs. We prove the evidence. We prove what the prosecutor did. Now, at their hearing, when I was given a subpoena for someone I don't know where she lived, it was signed and granted, but wouldn't sign the other 3, where 2 was located in the courtroom and 1 was incarcerated. Like, that's what I don't understand. When he had me draw up the questions that I was going to ask them, yes, I wanted to know, get them on the stand, raise their right hand, I wanted to know why wasn't the letters turned over. I wanted to know all that. This is something where the prosecution got more leeway than the defendants, or some might say criminals, but I'm no criminal. And the prosecutor that tried me the last time, her name was Sandra Tullius. She had given witnesses secret signals. If they accept a glass of water, they will convict me. That's why Donna Mambrino said, no matter what, I'm getting convicted. See, it was because
Mr. Randolph, I want to just ask you quickly, why is it that you don't feel that you have a legitimate Brady claim here, which you could pursue via a habeas?
I have a legitimate Brady claim, but from my understanding and what I've read about the appellate court looks at everything, and it's not just one judge. They look at everything. They don't like when prosecutors withheld evidence. They don't like when prosecutors do anything to get a conviction.
But that's the same. That concern is covered under Brady. We don't need to debate it, but I don't understand why you have been reluctant to pursue this via habeas.
Because it's only one judge. Is only one judge, and still, I don't even know what the habeas was filed for. But
okay, all right.
Excuse me. When you get newly
your time is up. Thank you, Mr. Randolph, and thank you, Attorney Chupak. We are concluding this virtual hearing on AC 42742. We will take the issues under consideration and issue an opinion.